Very good.
Very good.
Call to order the Board of Zoning Appeals meeting for March 16th, 2023. Roll call.
Mr. Shipley?
Here.
Mr. Treves?
Here.
Ms. Ross?
Here.
Ms. Neff?
Here.
And Ms. Sundar?
Yep.
We have a quorum. Also here is our alternate members, Ms. Pam Foster and then Mr. Steve Totsky as well. So. Good to be there, everyone. So we have Mr. Pete Griggs here from Brocious, Johnson and Griggs, and then Ms. Julie Donnan. Okay, great. From the same firm, here tonight to give you folks a presentation, kind of talk about the Board of Zoning Appeals, what you guys do, your role, and your responsibilities. So Pete, go ahead and take it away.
So Julie got married a couple weeks ago. So that was the reason for the, yeah. She's been called many things over the years, but also Julie now, as of the first of the year, is actually my partner. So congratulations to her. Yes, exactly. Yeah. I'm stuck with her. So I know this is going to be a little bit, some of this is going to be a little repeat for some of you, but it's a good refresher, I think, for everybody. So I'm going to kind of like skip kind of the very basic introductory stuff and just kind of jump right into the meat and potatoes. For those of you that haven't met me, my name's Pete Griggs. Our firm serves as special counsel to the township. I've been doing this now for, I think, going on 22 years. Julie's been about 9 years. So my practice is probably 90% township. We do represent a couple municipalities and villages, and then we do work we actually represent Delaware Regional Planning Commission, and then there's a few other regional planning commissions that we represent in the state as well. So a large percentage of our practice is devoted to land use, zoning. We also serve a lot of times as special counsel for the Howard Township Association. So when townships get sued, Heidi at OTA will pick up the phone and say, hey, can you help the township out? So we'll often file pleadings, and a lot of that is in zoning cases. And, we have seen, I like this, pretty much everything from conditional uses to appeals. Was in Liberty Township a couple years ago on an appeal of a zoning inspector's determination as to whether something constituted a fence or not. And the BZA had their own attorney. I represented the zoning inspector. The property owner had their attorney. The abutting property owner on both sides had their attorneys. The HOA had their own attorney. All over whether a dirt mound constituted a fence based upon the definition. In that case, actually went all the way up to the Court of Appeals. So, it's fascinating work. And, that case just kind of goes to show you never know which one, what application you get in front of you is going to kind of end up in court. So what I really want you guys, and I know Kelvin and Aaron and some of the others know this already, but what I really want you to do is to take away your role in this whole thing of zoning. So you have the zoning commission and then the trustees, and their job is really to make policy considerations as to what the zoning should be for a particular property. The BZA is, you don't set policy, right? You are what they call a quasi-judicial body. So what does that mean? It means you're judges, right? So zoning commission, trustees set the zoning for the properties. You then determine whether or not, based upon the law, the policy, as to whether or not deviations or, and with respect to a conditional use, or you're interpreting the text in the code. So I really want you to take away that role. And then the other thing that I want you to remember is articulate your reasons for a decision, which I think you guys do a pretty good job. So knowing your role in articulating, rationalizing a decision that you make. And I think if you do those two things, you're well ahead of the curve. I do training all over the state, and I would put you guys in terms of just knowledge and experience and kind of that upper echelon in terms of knowledge. And so feel free to ask questions. But to me, what does it mean to be a quasi-judicial body? And I think that tells me and should tell you a couple things. So, and I'm going to just talk real brief about the difference between zoning commission and BZA, because I think it'll help you understand why your role is the way it is. So when you're a quasi-judicial body, what does that tell me? It tells me that your decisions that you make are subject to appeal. There is a direct appeal to any decision that you make, automatic. The law says that anybody, Board of Zoning Appeals decision, whatever decision you make, is subject to an automatic appeal to the Court of Common Pleas. Okay, that's the first thing. Now you put on your zoning commission hat. That's not in trustee hat when they set the zoning for the property. There is no right to appeal their decisions. It may be subject to referendum by the residents, but a property owner, there is no direct appeal because, again, they're setting policy, right? It's the legislative process. So your decisions are always subject to appeal to the Court of Common Pleas. The second thing it tells me is, in my role, is how do I act with applicants? So in a rezoning context, when the trustees and the zoning commission are deciding what the zoning is going to be for the property, can they talk to, say a rezoning application is filed and I'm a developer and I want to come and meet with, I want to take the zoning commission chair for a cup of coffee and talk about my application. Is that okay? And the answer is yes, it is okay. It absolutely is okay because you're setting the policy. So, over the years, I've gone down with Heidi at OTA, and we've gone down and met with state legislators, and we've met and said, this piece of legislation, it's garbage, and these are the changes you need to make to it. Board of Zoning Appeals, remember, you're quasi-judicial. You're a judge. It's never okay. Well, in very limited circumstances, it's okay. But for the most part, it's never okay for a judge to meet. We're going to say ex parte by yourself with a witness or just with the prosecutor. That's why, the prosecutor and defense counsel are always, they always meet together with the judge. So you should never meet independently with an applicant outside of a hearing context. It's inappropriate because the argument is going to be from somebody on the other side that evidence was adduced outside of the trial, outside of the hearing, and that evidence that you have gained has biased you in your decision-making process. And I've seen that argued over the years. So a lot of times I get the question, hey, Pete, can we drive by the property or can we get out? I got a couple of townships where the BZA members want to be zoning inspectors. And then when an application is filed, they want to get out, they want to knock on the door, they want to say, hey, I'm so-and-so, I'm a BZA member, can I get out and walk around the property, you care about it, take a peek, and just naturally, right, organically, the property owner will say, sure, I don't care. And then they proceed to walk the property together and they're chatting, and that's a big no-no. But, I've been doing this long enough to know that if you want to drive by the property, I don't care. I mean, that's fine. Don't get out, knock on the door, and inspect the property and do those type of things. And the reason why is because that is an ex parte communication. Okay? Cannot meet with the applicant outside of the hearing context. And, your names are on the website and your emails are on the website. So if someone reaches out to you, simply say, I'm sorry, but, I'm unable to meet with you outside of the hearing. But I'll be at the hearing and you can talk about your application then. The other thing it tells me is when I'm doing my hearing, do I, as a BZA member, do I have the ability to go behind closed doors as a body, as a public body, and talk about the application? And I know you guys know this. The answer is yes, you do. And it's called a private deliberation. So again, think of yourself as a judge. Closing statements. The judge does not render a decision right there. In fact, they often take a couple years before they render a decision. But what a judge does then is goes back behind closed doors and comes up with a written decision. So you have the ability to adjourn adjourn the hearing for purposes of deliberating the merits of the application in private. Now, on the other side, rezoning with zoning commission and trustees, they have no ability to do that. Everything they have to do is on the record. They cannot meet privately. There is no, and it's not called an executive session. Executive session is a term of art, and there are 8 reasons under the law that public bodies can go into executive session. Rezoning is not one of them. Neither is private deliberations. Private deliberations is born out of case law by the Supreme Court. So the Supreme Court has consistently held, and it's we won a Court of Appeals case on a BZA, but there are other different types of quasi-judicial bodies in the state of Ohio for different agencies. And they have said that any quasi-judicial body has the inherent right to deliberate the merits of an application in private. So we'll get into why that's a good idea sometimes. Yeah, Stacy?
Sorry to interrupt you with a question. We don't have to have an attorney present to do that, right? Or do we?
No,
Okay.
you do not.
Okay.
Absolutely not.
The only time we've done it since I've been here, we had one, so I wasn't sure if that
Yeah.
was an anomaly.
So more often than not, you're only really going to do that when you get that kind of tough case. And the staff here is great, and they kind of know, and some of you guys know too, when you read an application, this is going to be a tough case. Maybe we need to have legal counsel here. So oftentimes we will be here, but if you ever feel like you need to and we're not here, and maybe it's a matter of you just getting kind of you're just not sure. Like, Kelvin is, seems to be kind of leaning one way by what he's talking about, and Aaron's leaning another way, and you're just not sure. And maybe recessing into private deliberations to talk about what you're hearing and formulating those questions and kind of where we think you may want to go as a body is a good idea. So you can do that. There's no requirement. There is what they call a pending litigation executive session or imminent litigation, and you are required to have an attorney present, but not for that. So my clients are always miffed when they say, well, we're going to go into executive session to talk about pending litigation. Like, you can have an attorney present, and they're like, we don't want to pay you to come out there. I'm like, well, hey, I didn't write the law. I'm just telling you, you got to have an attorney present. I mean, but no, you do not. You do not. The last thing it's going to tell me is how I run my hearing. As a quasi-judicial body, you're a judge, right? So, to make a long story short, if you have that contentious hearing, you need to dot your I's and cross your T's. And you think about what the trustees and the zoning commission, what they do, it's not the same. It's not the same. Again, you are basically getting input from people on policy. So there's much more flexibility. So in a rezoning context, can I put time limits on people when they speak? Absolutely. Absolutely. In fact, Julie did that last night. They had a room full of people here on a rezoning, and they put a 3-minute time limit on. Absolutely okay. And can you limit the number of speakers? You can. I don't recommend it. I mean, unless you want to lose votes. But yeah, absolutely. City of Columbus. Oftentimes, City of Columbus, they limit the number of speakers for and against a proposal. You guys can't do that. You just can't. And I'll tell you the reason why when we get into kind of the hearing process. So, quasi-judicial is the BZA. Legislative is the trustees and zoning commission. You can kind of see the difference. Your decisions subject to appeal. Trustees, no. You can't have ex parte communications with an applicant. As long as they're not violating the Sunshine Law, the trustees can meet with the developer outside of a hearing if they want. You can meet privately in the hearing context to discuss the application. Trustees and zoning commission can't. Your hearing formalities have to be, they have to be formal. Trustees do not. Trustees do not. Okay, so that's what I want you, that's kind of the big ticket that I want you to take away is you are a quasi-judicial body. You're acting as judges. So keep that in the back of your mind. Yeah, so, and then I'll get into actually what you guys do, which I know some of you already know, but do you have any questions just off the bat? Yeah, absolutely. No, ask questions. Yeah, I hate just standing up here talking. So please ask questions.
So you mentioned that if something comes through us, it's automatically subject to an appeal at the Court of Common Pleas.
Correct.
But if it goes through, so I guess I can't really think of an example. I was thinking, like, would there be a time? Well, let's say something is, I guess people could ask for, they would put in an application. I was trying to think of a time when someone might be at a disadvantage in a zoning matter because they it didn't meet like the HOA or something, but
that's a great question.
Didn't really qualify to come through here either, and then they had no remedy.
Here's what I would tell you with respect to HOAs. I'm pretty sure we don't enforce as part of our plan developments. We don't put language in development text that states we can enforce private deed restrictions. No. So there are townships that do that in terms of, so when property gets zoned, say you got a new subdivision going in, you're required to have development text as part of that process that the trustees approved, and that in a planned district, in addition to what's in the code, that also becomes the zoning for the property. And there are some townships that will actually require deed restrictions, not just as a sample, but they will make them part of the development text and specifically say they will enforce that. Outside of that situation, to me, it's irrelevant. as to whether or not somebody complies with their own private deed restrictions. And you say, well, that's important to us as a BZA, and it may well be, but it's not our job to enforce private deed restrictions. Certainly, I think the flip side to that is if they have a letter of HOA support, that would carry some weight. But what I would tell you is I want to see the HOA actually show up either way and have them make the argument as to whether or not I think that's something you could consider, but whether basing your decision on it doesn't meet HOA requirements in and of itself, in my opinion, is not enough. Is not enough. It may carry some weight, but what I like to see is the HOA actually formally enter into the process. That makes sense.
How many times have you actually seen that, though?
Oh, you'd be surprised.
Yeah.
Yeah. Well, the appeal that I was talking about in Liberty, they made an appearance
Okay.
through council. It's not often. A lot of times it's just a letter. And more often than not, it's when somebody knows what they're, the homeowner knows what they're doing, and they'll get, what you'll see is an HOA letter saying we don't have a problem with the variance application and it meets our HOA requirements. That's what you typically see. But what I would say is if someone is in front of you and that question is asked and they say, I don't know, I think that's their problem. Even if you were to grant the variance, it's still their problem. And they probably aren't going to be able to do something that violates their own restrictions, but it is what it is.
I think more often than not, what we see too, if we don't have an HOA letter in the package, we would tend not to know fully what the HOA restrictions may be.
Yeah.
And I think more often than not, when those packages come in, one of the things we look for is an HOA, just to know that the HOA is at least informed. And sometimes the HOA letter will say absolutely, pending BZA approval, pending township approval.
Yeah.
Something like that. And I think the homeowner, could be wrong, but I think the homeowner, if they had a letter that said absolutely not, they probably wouldn't be here.
Right.
They may,
You're right.
but
Absolutely.
But some of the HOAs are more sophisticated and knowledgeable than other HOAs.
You're right.
yeah,
That's true.
You're right.
And some go to the trainings, that are put on
Yeah.
by the different firms
Yeah.
where others don't.
Yeah.
And so they don't know
Right.
what their real.
And there are those that are defunct
that's
that don't have
true, right.
operating,
Yeah, exactly.
that have operating boards either. So I guess my point is just don't base it on the lack of, base your decision. So
Pete, I have a question.
Yeah.
Quick. So back to the private deliberations. Procedurally, do they have to do it similar to the trustees where they have to list everybody who's in attendance? And is it limited to just the board members and legal counsel?
So your motion should be a motion to recess the hearing for purposes of into private deliberations for the purpose of discussing the merits of this application in private. Second, roll call vote. No, you don't have to list. You don't have to list for the record who goes back. So this is what I would say about who goes back. It should be the BZA and legal counsel and nobody else. Okay, so staff technically is an adverse party in the proceedings. They often give testimony. You swear them in, correct? Right, which is good. You need to. So that you're taking evidence from staff. So the last thing you want to do is to invite them back. And to me, that's an ex parte communication. And I've had that case a couple times, and we've ended up still winning the cases. But what I don't want is to be spending 3 or 4 hours of time arguing something as foolish as that, having staff come back, because what the whoever doesn't like your decision argues that they are an adverse party and that they've biased you, and that evidence or testimony back there was not put on the record, and they had no ability to respond to it. So you don't. So it's a motion. You don't need to state on the record who goes back. You can have legal counsel back there with you, but outside of that, I wouldn't have anybody else.
Great, thank you.
Yep. So getting into what you hear, right? And some of you have been doing this long enough that you've heard all three of these things. But under the statute, under your chapter 519 of the Ohio Rise Code, it basically gives you, it's actually four, but one, I don't know how much mineral extraction we have going in the township. So it's really three areas. You decide appeals, you decide variances, and you decide conditional use permits. So appeals can take the form of many things. So what the law basically states is that any final determination by zoning staff can be appealed within 20 days of that determination. So that could be, let's see, I've had, say Brett sends a letter of zoning violation to somebody saying, hey, you constructed a fence that was in the setback. That's a zoning violation. One, you didn't get a permit, and two, you're in the setback. Somebody could appeal that decision directly to you. It's not a variance request. It's just an appeal. Let's say I got 5 acres in the township, and I want to put up a big old pole barn. And Brett sends me a letter and says, hey, that's a zoning violation. Number one, it's too big of an accessory structure and you didn't get a permit. But I say, well, you know what? I'm raising some chickens. And Brett says, nope, you're not an agricultural use. You have to comply with zoning. His determination as to whether or not something is agriculture is subject to appeal within 20 days to you. So you decide. So let's take that example. You would decide whether he's right or whether he's wrong. Now, I've often found that zoning inspectors are always right, and BZAs typically lean. They know who, brings in cupcakes during, or Christmas cookies and things like that. So you actually, or denial of, let's say a denial of a permit. If he were to deny a permit, it says that I'm denying permit based upon you did not meet the general parking standard, the general development standards for parking. That person can appeal that decision to you.
20 days is bothering me because we meet once a month. So does that, we have to call a special meeting?
No. So your hearing and your decision doesn't have to occur within 20 days. It's just I have to, as somebody who's going to appeal their decision, file a paper, and it's as easy. It can be an email that says, Brett, I hereby appeal your decision, and that's enough. So that tolls that 20 days, and now you have to then process it and hold a hearing. So not many. Not many. Doesn't happen. I'll tell you why, because a lot of people don't know they can do it, which is a good thing for me, because what happens is, let's say he sends a notice of zoning violation. And what most people typically do is, well, I should say most when I get involved have basically taken that and chucked it in a garbage can. And then I get a file that says, hey, Pete, we need to take this person to court. So we file an action in the Court of Common Pleas saying, Judge, we want an order forcing this person to comply with zoning. And the first thing that they want to argue, or their attorney wants to argue, is, well, he's wrong. And I'm like, maybe he is, maybe he isn't. But you never appealed his decision. You failed to exhaust your administrative remedies. And the proper body to make that determination was the BZA. So that's why it's really important.
I have a question. Would or should Brett in that scenario like recuse himself from that case in terms of preparing material, presenting it at
No.
the hearing? No.
No. So Jen in our office, she's another one of my partners. She Cardinal Storage was trying to do some sneaky stuff, and they filed a application, and the zoning inspector denied the application. Cardinal Storage brought in a big law firm and filed an appeal to the BZA. And so what I would tell you in that situation is you need to get a hold of our office or the prosecutor's office. And Jen actually presented on behalf of the zoning inspector. And it's basically very similar to what you would do in a staff report, but it's basically, Jen put the zoning inspector on the stand, if you will, and basically walk through the application, walk through the reasons, walk through the code, walk through the reasons of denial. And then also Jen had the ability to question Cardinal Storage representatives as, when they were providing the reasons why they thought they were right. So you're actually a party to the litigation at that point. So you're not recusing yourself.
When when charges are being filed against someone for a violation, that comes through the trustee, right? Like, don't the trustees have to make some decision?
Charges are being filed
For a nuisance.
For
zoning violation?
Repeated zoning violations, like
Yeah.
someone.
So this is what most places will do. They will basically, they already have their own internal policy. Normally it's hey, we have zoning. Hey, I sent you something, you ignore me. Please comply. And then the third thing you usually get is the nasty letter saying you're in violation. Abate the zoning violation. And then if that's ignored, what I always advise our clients to do is before the file comes to our office to go to court, I always have the trustees approve the filing. And there's a couple reasons for that, but what I found is those people often complain to the trustees directly, and they're the elected officials, so I want them to be aware of the decision to file. So that's how we would pursue kind of a zone, and actually going to court as a last gasp effort to get that person to comply. Now, there's nuisances. What Brett was saying, there's like nuisances that a trustee, someone's grass grows up to here, zombie property, right? Foreclosed. There's a process that you can follow outside of zoning, where the trustees actually declare that a nuisance, and it never goes to court. But yeah, so they would present to, and normally zoning staff gets stuck with doing all that stuff. Somewhere along the lines, most people say, "Wow, zoning, it's land, so we're going to give these guys nuisance authority." But yeah, before we go to court, we always recommend the trustees approve an action. But it doesn't happen very often, right? It just depends. But be aware that that's one of your jobs, is to decide that appeal. In terms of who can appeal a decision, it's interesting because the statute uses the word any person aggrieved, but it doesn't provide further definition. So typically, who can do that? Who can appeal the decision is, the property owner, obviously, anybody that's contiguous or adjacent. But once you get outside of that, there's a legal issue. And it's really trying to figure out who has standing. And like I said, the court cases are all over the place, but what I can tell you as property owner and anybody that's contiguous adjacent, definitely you're going to have standing. Outside of that, that's, those are lawsuits and cases and things like that. Can the trustees appeal one of his decisions? And the answer is no, and they can't. Now, Brett's an employee at will, they can fire him, but but they can't appeal his decision. Or an HOA can't appeal one of his decisions. So, so if you get an appeal, you're required by law, unless your code says otherwise, to decide an appeal within a reasonable period of time. Do we list 30 days in our code?
I'd have to double check, but
Shouldn't, and we're going through code rewrite, so
yeah.
I haven't looked at it yet, but I'll change it if it is. So you're required to decide an appeal once you have your hearing, close your hearing. There's no obligation to render a decision that night. You're required under the law to decide the case within a reasonable period of time. And typically what I tell people is, if you meet once a month, try to have your decision by the next month. But you're not required to, but you just don't want to drag it out. Reasonable period of time. And then the BZA is also required to give, when an appeal is had, to give 10 days prior written notice of your hearing to parties in interest, quote unquote, and that, like aggrieved, is not defined. But just like aggrieved, it's contiguous, adjacent, and then codes often expand that notification to, what do we do?
200.
200. So anybody within 200 feet would get notice. Okay. So what I would tell you is, you guys are good. I like 200 feet. I have some townships that still do 1,000. 1,000 back in the day was very common. And what happened was, well, townships are very reactionary. They don't do things until it's a problem, or they don't. It's just the way of life, right? So you had all these old codes out there that had been written in the 60s and 70s that weren't changed forever. And then, and particularly here in Central Ohio, and then wham, Central Ohio grew so fast. And people were like, do you realize how much it costs us to send out? Particularly, I mean, can you imagine here in Orange Township and all the subdivisions and condos that you have within 1,000 feet? And they're like, I'm like, well, why do you have it in there? They're like, well, that's the law. I'm like, well, that was law, but you change it because here's what the law says. So a lot of townships in the last decade or so have drawn that down. Again, I'm a by the book type of guy. I just say follow the statute, but I understand some trustees will, want to try to expand upon that, because a lot of times you hear, well, we didn't get notification. Well, you're half a mile away. I don't know why you would. So, but I get it. So that's what it says in terms of who gets notices. So, yeah, that's appeals, and they don't happen very often. But be aware that's one of your jobs. The next job, conditional uses. Those are uses that are not permitted under your zoning resolution, but may be permitted upon your approval. So I'm a big fan of conditional uses. So what I tell clients all the time is, if you're kind of on the fence as to whether or not you want to treat something as a permitted use, put it as a conditional use, and then let the BZA review it. And the reason it's a conditional use is that it has the chance of having a greater impact on adjoining property. So we're going to require it to be specially reviewed by the BZA to make sure that they can address any of those potential impacts. Or could be that the impacts are so severe we don't allow for them. Right? So uses that are not permitted, but may be permitted. And you can only grant conditional uses for those that are specifically listed in your code. So if it's not listed in your code as a conditional use, you don't have any authority to grant it. Okay? In terms of what you...
I have a question.
Yeah.
Is there a term limit for that conditional use, or is conditional use forever and ever? You know, perpetuity?
What I would say, and I think you guys do this, it runs with the land. It runs with the land. I think you do that with variance as well, correct? For the most part.
Correct, yeah.
Yeah. Which I believe, right? I mean, you don't want to, just because I sell. I mean, I'll give you an example. I mean, in one township, self-storage. I'm getting another self-storage case. It was listed as conditional use. So went to the BZA. BZA approved it. They build it, and then company sells it to somebody else, right? There's not a court in the world that's going to make that person come back in and apply for that conditional use. So they typically run with the land, but it's a good question. You see some townships try to play a game more with variances, some variances on, and try to make them personal. But yeah, run everything with the land. Now, there may be an occasion where I've seen variances be temporary, is where you have a significantly large lot and it's got an old farmhouse on it. And it's like 15 acres and the person's constructing a new house on, so you allow a temporary variance for them to live in, because essentially you're going to have two principal structures on one lot. So that variance would expire for the house they're currently living in when they move into the new house, and then they have to demolish the old one. That's an example of a temporary variance. So conditional use is in your code, as you guys know, will list. Sometimes it'll list certain factors or certain criteria. With respect to conditional uses, home occupations, is that a conditional use here, or is that permitted? Yeah. So is one of the requirements that you can't have employees?
There's a limit depending on the zoning.
Yeah, so you guys know that. So a lot of times you'll have a limit on the number of employees that you can have. So you're going to look at the specific criteria for that particular conditional use. And then you're going to have more general, what I like to call fuzzy standards. I love standards like that because I can make it mean whatever I want it to mean. But those are like, doesn't substantially impact the character of the neighborhood. Just broad standards as opposed to your specific standards. What maybe it says no more than one employee, no off-street parking, or no, you don't get a sign. Those type of specific standards. So that's what you base your decisions on. What's in your code? The question it's come up a couple times recently in our office is, can I grant a variance from a conditional use standard? So let's take home occupation. Code says no more than one employee. And I come to you and I file conditional use, and I also request a variance from that standard because I'm going to have 2 employees. Can I do that?
Is it a use variance?
Good question. I think you can. So what I would tell you is you always have to allow somebody to request a variance. There's a case on that. So I think you can. I absolutely think you can. Do I think you should? I would say super majority of the time, no. I don't think you should, unless there's a really, really good reason to. Okay? But I've had applications where someone is requesting a conditional use, and then they are also requesting variances from those standards listed in a conditional use. And it makes it complicated. It's like the chicken or the egg. But typically, what I do is decide the conditional use first and determine whether that's appropriate, and then I will then render decision on their variance request.
On the variance,
Mhm.
if we grant the conditional use, and now they want a variance, doesn't that kick in additional things that we have?
Absolutely, it does. So self-storage facilities are really controversial. I mean, so I had one where conditional use, but they couldn't meet all the requirements. I think there was like a setback issue and there was a lighting issue. So they filed their conditional use application, and this was hotly contested. So we closed the hearing, and I wrote a decision. But I actually rendered the decision for the board on the condition of use. Then I went secondarily and said, here are the area requirements for each variance that they requested. And based upon the Duncan B. Middlefield factors, which we'll get into in a minute, here's the rationale for that. Absolutely. That's a great question. And you take each one separately. Mm-hmm. It's rare. But it does happen. But I'm not a big fan of it, because I think when the trustees and the zoning commission are setting that policy, they're letting you know that these are things we do not want to see, right? So there should be, you should never tell somebody they can't, but I think you need to be very careful if you do, if it ever comes up. So that's conditional uses. And let's say one last thing, we won this court case. It's been years ago. It was one of the very first court cases that I was involved in Liberty Township. Somebody wanted to put in a heliport. God bless Southern Delaware County, right? Someone wanted to put in a heliport in their backyard, which was a conditional use of all things. And they met all the technical requirements in terms of size of the heliport, setbacks, checked all the boxes. But obviously the neighbors were pissed.
You go 1,000 feet out.
Right. You know what's funny is we did. It was an old code. This was 19 years ago. And, neighbors turned out in droves, and they actually hired, somebody actually hired a sound expert. But at the end of the day, even though the applicant met all the technical requirements, the language in their code said may grant. It's permissive. And the BZA basically said, look, the noise impact is going to be too significant. So they appealed it, and the court said, yeah, I understand you met all the technical requirements, but it's not permitted. It may be permitted, and here's why. And that was a good reason. So know that if an applicant comes in, even though they check all those boxes, if there's another reason why you feel it's inappropriate, look at that general language and base your denial on that. A fascinating case. They also, in that case, argued that it was the first time a court decided the private deliberations issue for a BZA. So it was a multi-appeal. They argued that the BZA violated the Sunshine Law. The court said, nope. Supreme Court case, they're quasi-judicial, perfectly fine. So the meat and potatoes of what you do is variances, right? You got a use variance and you got an area variance. So two types of variances. Prior to 1984, there was one standard, and that was what they called it's an unnecessary hardship. An unnecessary hardship was the only standard for any variance. When you looked at what unnecessary hardship meant under court cases, theoretically, no one should really ever have been given any variance whatsoever. Because one of the factors for an unnecessary hardship is that you cannot create your own hardship. You can't have self-imposed hardship, right? So, right, I buy my house and I decide I want to put in a pool or a deck, and I want to encroach. I just want to make my deck just a little bit bigger, and I'm going to be in the setback by a foot and a half. Whose hardship is that? That's your hardship. You're creating your own hardship because you want to violate the code. So in 1984, the Supreme Court basically said, time out. This is crazy. Rather than the General Assembly fixing it, the court basically says, we're going to create two different tests. One for use variances, one for what we're going to call area variances. So use variance is, using property in a way that is not permitted under your code. So the actual use. So the famous court case is out of Youngstown, the Bartolo family. I mean, they own the 49ers, very wealthy family. They had property that was zoned commercial. They wanted to put one of their strip malls up, but they needed a little bit more land, so they bought property right next to it that was zoned residential. Rather than rezoning the property, and the reason why they didn't rezone the property because they didn't have the votes on council. So they went to the BZA and applied for a use variance. And the court, or the BZA, granted it. Said you can use residentially zoned property for commercial use. That's a use variance. It was later thrown out because they created their own hardship. But so that's a use variance. An area variance is pretty much everything else. It gets complicated sometimes, but it's pretty much everything else. So setbacks, height, size, you guys probably, you see it all the time. So typically you're doing area variances. And what the court said in 1984 is, look, the impact on area variances is not as significant as it is with the use variance, right? We're not throwing commercial uses on property in a residential zoned area. These are uses that, or these are things that don't have the same risk of substantially impacting adjoining properties. So we think there should be a lesser standard. So instead of an unnecessary hardship standard, we are going to do what we call a practical difficulty standard. And so the case was Duncan v. Middlefield. So people like me call those the Duncan factors. And there's a list of them. And I think they have them, right? Yep, you all have it. So that's the genesis of those factors that you have is from that case, the Duncan v. Middlefield case. So what the court has said is that at a minimum, those are the 7 things that you should look at each and every time that somebody it comes in front of you for an area variance. What I would tell you is that if you have other reasons, it's not limited just to those 7 things. You can go beyond that. Zoning inspector mistake. Let's say the zoning inspector said I could put my shed up where I put it up, issued me a permit. Well, a new zoning inspector comes in, says, you cannot have a shed right on the property line. right? Theoretically, that person, even though a permit was issued, they have to come and get a variance from you guys. And one of the factors you can consider is error of the zoning inspector. So there are other things other than those seven. And what the court has said is, look, it's a balancing test. So you have those factors. Let me get to them. You have those factors, and we want you to weigh them. And we want you to balance them. And we want you to render a decision as to whether that property owner is experiencing practical difficulties. It's not like unnecessary hardship, where if you create your own hardship, you're automatically out, which again happens in 99.9% of the cases. So lesser impact, we want you to balance those tests. And those 7 things are listed. And you know, I know we've talked a lot about some of those factors last time. One of the factors that is very easy to decide is number 2 on that list, whether the variance is substantial. So what is substantial, Pete? Well, what the courts have held is that if the applicant is deviating 25% or more from the standard, that is substantial. But here's what I would say to that. That's one factor, right? We're not in an unnecessary hardship situation. So yeah, that may be a check against them. But what the case law says is you have to consider the other factors. So balance that. So that should not be the end all be all. It's just but a factor. You know, some of the other ones, you know, are pretty self-explanatory. The other thing, and I've been in a few of your BZA hearings, and I hear this a lot too, is, well, Pete, what about precedent? What about precedent? So I thought I would pull a case, because a lot of times I tell people, yeah, you know, you always kind of keep that in the back of your mind, right? But each and every case is different. It really is. And while you have to have the precedent nugget in the back of your mind, I don't want applicants coming in here, and particularly ones that represent developers in big projects, bullying you, saying, well, you did it for them, you got to do it for us. So this case is out of Trumbull County. Jim Matthews represented the township. Jim is a good friend of mine. We work in a couple townships together, and he is, so when townships get sued, obviously they have insurance, right? So rather than pay full rate for someone like me to defend them, they pick up the phone and call the insurance company, and the insurance company will appoint insurance counsel. And typically the township's just out their deductible. And so Jim's one of the guys that he's a defense attorney. That's what his firm does. So this was a case, Burlington Coat Factory. And I know some of you are going to get a kick out of this. And Burlington Coat Factory came in with a bunch of variances for a new store because they were requesting additional square foot for signs. And one of the things that they argued and what they provided to BZA was a hardship visibility study. And it said Burlington is set back from the roadway anywhere from 965 feet to 1,300 feet, depending on the measure point. We were also, they were requesting a 50% increase in the allowable square footage of the sign area. And the BZA voted no, denied it. On appeal, as part of the supplemental filings in the court, Burlington demonstrated that at least 8 other businesses in or around the shopping center where they were located requested variance. It had been granted by the same BZA. including a request for the exact same variance at the same location. Right?
Yep.
Turns out the BZA liked linen and things better than they liked Burlington Coat Factory. But the court upheld the BZA's decision. Why? Because they had a good attorney, and their attorney had them follow the Duncan factors, and the court said, look, they went through the factors, and they articulated their rationale under each of the factors. And we're required by law to give deference to the BZA. So, should they or shouldn't they have granted that? I don't know. I don't know why they didn't, right? But my point is that precedent should not necessarily determine whether you approve or grant a variance application. Okay? If you have a reason, even if you granted it there, if there's a reason why you don't think you should grant it here, then you deny it, right? And you articulate your reasons. I know I hear a lot of times these people coming in talking about, well, in a PD or, well, that's a PD, right? That's not, we can't really control that. That is what that was approved as part of a plan development. That's different than what we have in a commercially zoned standard district. So be aware of that. Certainly, you may feel as individuals that I remember sitting on that case, and I remember, same fact pattern, and your same thought process may apply. It may. But don't be intimidated by somebody that shows up and says, you did the same thing here. If you have a reason, state it, and you're good. So I thought you would appreciate that, because I know that I've sat through a couple signed cases and heard the same thing, didn't we? That's variances. So appeals, conditional use, variances. Any questions?
I guess I'm new to this entire process in a lot of ways, but trying to understand if someone walks up and presents a hardship that I believe to be self-caused, what is the roadmap for trying to understand how I would state that?
Yeah, so what I would say is if it's an area variance, if someone deviating from height, setbacks, size, it's under the law, the term of art is practical difficulty. And these right here are the 7 factors that you should have. And one of them is almost inevitably what I would call kind of an element or a carryover from the unnecessary hardship standard. And that is, did the property owner purchase the property with knowledge of the zoning restriction? And that's kind of the old self-imposed hardship rule. Exactly. But remember, we're just saying that's a factor now. We're not saying that's the end all be all. So really what you do is, and again, the easy one is whether or not the variance is substantial, right? Well, 10-foot setback, they only want to deviate a foot. It's the application says we're only requesting a 1-foot variance. That's 10%. Therefore, I determine that the variance is not substantial. Whether the variance will adversely affect the delivery of governmental services like water, sewer, and garbage. We really don't have any testimony tonight on that issue, but I don't believe that it would impact the delivery of governmental services. Did the property owner purchase the property with knowledge of restriction? That knowledge is known or should have known. And inevitably, yes, we've had zoning in place. They should have known. So that's a check against it. So that's all you're really doing is going down through those factors and trying to articulate a reason why. The hard part becomes when you start getting in some of these kind of gray area, whether the essential character of the neighborhood would be substantially altered, or would the neighboring property suffer a substantial detriment. Well, certainly if the neighbors show up and they're supportive of it, kind of hard to say that it's going to suffer a substantial detriment if the neighbors are supportive of it. And vice versa, if everybody shows up and is opposed to it, your job is to try to get them to explain why. Why would they suffer a substantial detriment? And the hard part in this is, remember, what are you? You're judges. You often get a lot of speculative testimony. It's opinions. It's going to be crime, there's going to be too much noise, there's going to be too much sight. Well, do you have anything to back that up? Often they don't, right? Which makes your jobs difficult. But that's really, I don't know if I'm answering your question, but that's really what you're trying to do during the hearing.
Yeah, maybe as like an example, I think someone had come in and said something about how their contractor had submitted to the HOA,
Yep.
not here. And so what they said was, that's a hardship. And so
Not necessarily.
to me, it's not.
It's not a hardship.
Or it's a self-inflicted hardship.
What I would say is to that is we appreciate that, but based upon what you've presented, my criteria is you purchased the property with knowledge of the zoning restrictions, and whether you're doing your project yourself or whether you have an agent doing it on your behalf, that's not a hardship. That's a factor you can consider. Now, I think there's been an occasion where maybe it's been even a little more. Well, I think it was fraud myself, and I really do think you could. Personally, I think you could consider that. I think you can consider that. I do. So, but to me, if I'm looking at the first 7, he purchased the property with the knowledge of their zoning restriction, which is really kind of the old unnecessary hardship standard. And but at the same time, I can go outside those 7 factors as well. And if it's so absurd, maybe you as a BZA member take that into account in making your decision. Judges are humans. You guys are human. You certainly can consider that, but doesn't mean that just because their contractor screwed up that they're entitled to it. I agree with you 100%.
Yeah.
But it's just a factor I think you can consider.
Technically, it's still on them to
Absolutely.
go through the process.
Absolutely.
And make sure they're
Absolutely.
contracted.
I just think, there's, I'm not sure I've ever seen one like that, but, it gets so, sometimes it can get so egregious that, maybe you take that into account. So, but that's a really rare
And I think
case.
that flips to the seventh option of whether substantial justice will be
Yep.
done. Right.
Yep.
We talked about that.
Yeah, and that's kind of the catch-all. That's kind of what some court cases have basically said, really with the first 6 factors, really what you're trying to do is figure out number 7, like Julie said. Is substantial justice done by granting a variance? That's really what you're trying to figure out. So, but some of those things are, I tell people all the time, I love words like reasonable. You can argue that stuff all day long. So, but great question. So conducting the hearing, I've got a lot of stuff in there, and I'm just going to hit really briefly. You have to be formal. You guys swear people in already. You can't. I would be very cautious of limiting somebody's ability to testify. So people say, you know, if I have a room full of people, can I limit people's ability to testify? So what I would say is what you're really trying to do is figure out who has standing to appeal your decision. Right? So the applicant, you should never limit, put a time limit on their testimony. Adjoining or contiguous property owners, you should never put a time limit on their ability to present testimony to you. Outside of that, I think legally you have the ability. The problem is trying to figure out whether somebody has standing to appeal your decision.
How do you determine that? Do you ask them their address and then we go to a map and find they're at 205 feet, so
Yeah.
they don't have standing?
Yeah, well, and what I would say with respect to that is here's the rule. The courts have held that contiguous, adjacent, directly across the street, property, all have standing.
Sure.
Outside of that, a property owner or somebody is required to show special harm. Harm that is unique to them as an individual and not shared with the community as a whole. And that's really difficult. We won a lot of cases on standing. And, you know, what I would tell you is 200 feet if you've expanded upon that. That's a rule of thumb, but I'm trying to think of a case where somebody was outside of either that court imposed standing or the notification where they've been granted standing, and I can't think of one. We've had people try to, but we always get their lawsuits thrown out. You could, which brings me to my point. 99% of our clients don't do that because they don't want to waste the time. And they use the other things that you guys use in terms of, you know, controlling, you know, we've heard 5 people talk about, you know, noise. We get it. We understand it. Does somebody else want to testify on something else other than noise? And that usually controls it. But you don't want to limit. Have you had anybody, any attorneys yet show up or anybody try to cross-examine?
Oh, yeah.
Yeah, that's always fun. You have to allow for cross-examination. So let's say you don't have an attorney. Let's say you have next door neighbor, applicant. Applicant gets up, gives a spiel. Next door neighbor says, Mr. Chair, I'd like to cross-examine the applicant. You have to allow for it. Yep.
So they're asking questions directly to the applicant.
Yeah, I mean, you can do it one or two ways. I say as long as they're courteous, I usually let that conversation occur. If it gets out of hand, then, you know, you can basically just say run it through the chair. Yeah, but for the most part. In fact, the only times I've had to do it is because attorneys couldn't be professional. But you have to allow for cross-examination. We have a sample hearing format, which you guys do not need in the materials. You already do a great job. Relevant testimony, again, you try to have factual testimony, but for the most part, what you're hearing is straight out opinion. Let me give you an example of factual testimony. Self-storage. Neighbors were completely upset because right behind it was a platted subdivision, like 350 homes. Conditional use was filed on that property that sat on kind of a main thoroughfare. Resident after resident showed up. Traffic, noise, light. Do you know what type of people rent? I didn't know that people, manufactured meth out of those things all the time. I mean, according to the testimony from the residents. The applicant showed up with a certified real estate appraiser, from all their other properties in Central Ohio, showing the study that did not impact adjoining property values. They had a lighting expert. They had a sound expert. They had a traffic expert that come in that showed that this is the traffic. These are the times of days. That is factual evidence, isn't it? I mean, that's evidence from an expert. FedEx, probably the best conditional use application presentation that I've ever seen in my entire life was put on by FedEx in Jerome Township off Industrial Parkway. They brought in every kind of expert that you could think of. And not only were they experts, they were from MIT.
Oh my.
And the amount of paperwork, I'm not kidding you, was like this tall. And they had, I mean, they're in the logistics business, right? I mean, it was amazing the number of residents that went up and talked about the traffic impact. And, you know, here I have a stack of papers aside from MIT logistic professionals and experts saying that it's not what you think it is. You know, how can I base a decision on, right? And that's the hard part of what you do is when you have a room full of people that are angry at you, but yet the factual evidence in front of you states otherwise. So try to get in those contentious cases. Try to really, and I have some chairs that basically would say, is that just your opinion, or do you have anything to back that up? So keep that in the back of your mind. Problems with poorly worded zoning resolutions. So this is what I would say. If you ever get in a situation where there's an ambiguity in your code, that you can look at that code and you can say, I can see that. I can also see that. The general rule of thumb is ties go to the property owner for free use of the property. Okay? The property ownership is a fundamental tenet of America. So free use of property. Legal term, res judicata. So if I deny somebody a variance request, can I come back in and file the exact same application with you next year? And the answer is no, unless I show a substantial change in circumstance. So I can't keep, I had one up in Berkshire Township where a guy filed the same stinking application with the township 3 times in 3 years. So finally on the last one, they asked me to come sit for it. And we actually held the hearing, but we denied the application under the theory of res judicata, right? At some point in time, your decision has to be final. And if somebody doesn't appeal your decision to the Court of Common Pleas, you can't keep coming back and asking the same dang thing over and over. So unless an applicant shows a substantial change in circumstances, when you render a decision on the application and it's not appealed, it's the law. It's the law for that property. So substantial change in circumstance, it's almost kind of like the Duncan factors. So let's say and a lot of times court will look at that 25% if it's with respect to area variances. You know, have I reduced what I'm asking for by 25% or more? And if I have, that's probably substantial. So maybe I wanted a 2,000 square foot accessory structure, but now I've put it down to 1,200 feet. That's a change in circumstance. I can ask for that. But what I can't continue to ask for is the 2,000 square foot over and over again. Hopefully I get, some new people on there. Okay. Reconsideration. Do you have the ability to reconsider your own decision? The answer is you do, for a limited period of time. Wouldn't recommend it unless something's a little off, but you do. So you're not going to pick up the higher revised code and find it in there. It's a court-imposed doctrine that basically says a quasi-judicial body has the inherent right to reconsider their own decision within 30 days of their decision or until someone appeals your decision. So you guys render a decision, and 2 days later, I'm the property owner, I appeal it, you can't reconsider your decision. You've lost jurisdiction. But let's say 2 weeks go by and this doesn't happen very often, but let's say you only had 3 members there. I'm trying to think of examples. And maybe the vote probably would have been different. I've had a BZA member ask for reconsideration of that decision. And what I would say is it's up to this body. So in that particular case, they held a special meeting. They talked about it, and someone made a motion to reconsider the decision. And that motion passed. So they reconsidered, notified the property owner that we're going to reconsider your application. You follow the same notification procedures as a normal application, and you hold a hearing. Doesn't happen. I've only probably had it 3 or 4 times in 20-some years that I've done it. I'm not a big fan of it, but it's good to know that it's there if you need it.
Can you back up? You said that we have the right to reconsider,
Right?
Unless they've already.
Exactly right. Unless they've appealed. So you've lost jurisdiction. Once they go to the Court of Common Pleas and file that paperwork, you're done. You can't reconsider your own decision. Or if it's 35 days after your decision, you've lost it as well.
Are there, to that point, are there any rules about us talking about a case prior or after?
Yep.
What is that?
It's almost like ex parte communication. So you're a public body. You're subject to the sunshine laws.
Okay.
Now you can certainly go within your hearing format within your meeting. You have a public meeting. Within that public meeting, you have a public hearing. And because of the court doctrine of private deliberations, you're able to talk behind closed doors. Otherwise, everything has got to be during your hearing and or a public meeting. Yep. And so the question would be that sometimes I get is, well, it's just 2 of us, and it's not a quorum, so it's technically not a quote unquote public meeting. And what I would say to you is the same thing that you don't want to be arguing if someone finds out about it, the undue bias. Now, there's the only really caveat to that is you've closed your hearing and you are writing your decision. Typically, if you're writing that decision, it means you're going to have legal counsel in to help you write it. That'll all be subject to attorney-client privilege. And I think you can communicate with your counsel when they're writing that decision. But outside of it, no. No. Because the first thing I tell people that is going to happen, usually in government, when somebody does something that they don't like, they allege a sunshine law violation, and then they file a public records request. Those are the 2 things. I mean, hell, I think I've put one of my kids through college on the amount of time I've spent answering public records requests. It's amazing. It's amazing. So, but so, you know, at the end of the day, when you say, Pete, why did people have to be sworn in? At the bottom of page 11, there is there's a list of things that a court of common pleas is able to open up your record and take new testimony. So if you do everything right and you render a decision and someone appeals your decision, a court is confined to give you 1, deference on your decision, and 2, is confined to the record that you've created. So a court can't take additional testimony on appeal unless you screwed one of those things up. And that's what the statute says. You know, you didn't let somebody cross-examine the witness. Testimony was not given under oath. The appealing party was refused the opportunity to issue a subpoena. You do have subpoena power. The party was not permitted to testify. So if I'm the next door neighbor and you say, hey, Pete, it's getting late, 7:30 March Madness, who would ever schedule zoning training on March Madness? You only have 3 minutes. If I appeal your decision, I say, Judge, I didn't get my full opportunity to present testimony. So that's what you're really trying to do there by dotting those I's and crossing the T's. The last thing that I'm going to mention is, I know the old timers know this. Newbies, you are subject to the Ohio ethics laws, which means you can be fined or go to jail if you screw up. Typically, the only time you're going to jail is if you start taking bribes. Otherwise, you're probably just going to get a misdemeanor. Have to do community service, working the right away, picking up trash. No, I'm just kidding. But so you are subject to Ohio ethics standards. So obviously, the easy stuff is you can't take bribes. The hard part is that trying to figure out when I have an inherent ethical conflict. And what the rule is that I cannot use the authority of my office to secure a thing of value for me, my family, or my business associate. And thing of value means a benefit or a detriment. So you is easy, right? So if Brett lives next to me, he comes in and files a variance application. Whether or not that decision is that is granted or denied could be a benefit or detriment to my property values. So I have to recuse myself, right? Let's say Brett's my brother. He comes in and files a variance application. I have to recuse myself. Family means immediate family. Means mom, dad, kids, spouse, brothers, sisters, or anybody residing in your house. Outside of that, it's not considered immediate family. And what I would tell you is you make your own personal decision as whether you think you could be unbiased or not. So if your first cousin shows up, technically that's not an ethical conflict under Ohio law. You can sit. But, if you guys hung out at Alum Creek every summer together, that's for you to decide. So, and then business associate, maybe you're part of some LLC. If your partner comes in and applies, you have to recuse yourself. Now, I've had a situation, I had a nurse with Ohio Health. Ohio Health came in and requested a setback variance on a new facility. And I'm like, no, you can hear it. You're one of tens of thousands of employees. You're not on the board of directors. You can't, you're fine. So under that situation, now, let's say you were on the board of directors. Yeah, that's different. But being an employee in a massive corporation isn't considered a conflict under Ohio law. Okay, so be aware of that situation. It's much easier for a BZA to make a determination of whether you have an ethical conflict. Again, if you are contiguous or adjacent, or you receive notification from the township, recuse yourself. And by recuse yourself, you cannot talk about the application with anybody before or after, which you should do anyway. You don't sit. What I would do is if someone has a conflict, I would, alternate probably needs to sit. But you can, if you have 3 applications on the agenda, do the one that you have a conflict on last. Sit for the first 2, then stand up, say, hey, got a conflict? Sit the alternate, and just go home. watch the basketball game. Can you tell I'm a big basketball fan?
Is it same for the neighbor, like, that happened, like, I believe twice? And I'm guessing it would happen more because my neighborhood is like very popular coming here. They all want swimming pool, so most of the time. I think the reason two of them was sunroom extension or some sort of, I don't know them, because I don't know all my neighbors, Yeah. One neighbor I know, like somehow, but then, I was requested by the township to refuse myself.
Yeah.
So I just wanted,
Yeah, so again, if your property is contiguous or adjacent, or you receive notification from the township, you have an ethical obligation to recuse yourself.
Okay.
Outside of that, you have to make your own moral decision as to whether or not you think you can render an unbiased decision. I mean, guys I used to hang out, my college roommates, if one of them came in front of me, I would recuse myself. There's no way. All the beer we drank together and all that stuff. Seriously, I am such good friends with certain people that I know I couldn't be unbiased. But it's not an ethical conflict. It's just a moral one. And that you have to decide for yourself. So let's say you don't receive notification and they're around the corner and you just know them they live in your neighborhood, maybe through Halloween or school or whatever. You can sit under the Ohio ethics law, right? You just decide for yourself whether,
Thank you.
Yeah.
I need one more clarification on
Sure,
that.
go, absolutely.
So, by the way, township is first for me, so I would happily refuse and stay back.
Yeah.
But then you mentioned, like, if there is 3 cases, so I can can I come, does it apply the same? I can take the
Yeah, I'll leave it. It's up to you. Yeah, I've had situations where, someone will call and say, hey, there's only 2 applications and I really would rather just not come because I'm conflicted on one. Can you get the alternate? That shouldn't be a problem. Or if you want to hear the one before, you're more than welcome to.
Okay.
It's whatever you want as a BZA member.
Thank you.
So that's the skinny.
That was very interesting.
One question.
Hmm?
I'm a member of a church.
Yep.
We have a sign out, and they're going to want to change the sign.
Yep.
Can I advise them on the zoning regulations?
Are they going to come in for a variance?
Yep.
No.
That's what I thought.
I'd say call zoning.
Yeah.
Yeah. I would.
Could I point them to the website where it's all?
Absolutely.
Okay.
Yep.
Because that's public information. So
Yeah, it is.
Go to the
Yeah.
website to look.
Yeah. Because the last thing you want is, not that anybody at your church would throw you under the rug, but Kelvin told me this was going to be a problem, or he told me this is what the code said.
I won't tell them what the code said. I'll point them to the code.
I tell my wife all the time, don't tell anybody in our neighborhood what I do.
Yeah, exactly.
Tell them you have no clue.
Which may not be far from wrong.
Yeah.
Pete, I have a procedural question for, let's say a variance application came through for a swimming pool, setback is 40 feet and they want to encroach 20 feet, so it's a 50% request.
Mhm.
And after some discussion with the board, they realized maybe this is too much. I want to reduce it down to 10 feet, which is a 25% request. What does the procedure look like for the board? Do they have to make a motion to accept the amended application?
Yes, they should.
Okay.
I always try to get that. I always try to get the applicant, and sometimes it takes prodding because they just don't know procedurally. But if they're smart, they're picking up on the fact that the BZA is not happy, and somehow you get to the point where all right, what about 10 foot? And would you like to amend your application to 10 feet? And they kind of look at you. Yes, yeah, what's that?
They can do that right there.
Absolutely.
They don't have to come back.
But get them to say, yes, I would like to amend my application. And then I always just, again, I think if it's not going to be appealed, is it fatal if you don't pass a motion? Probably, I mean, no. But if I'm in a contentious hearing, what I would do is I would have the BZA vote to accept the amended application as requested. And then you consider the amended application.
We usually state our conditions for the amendment.
Yeah.
The motion anyhow.
Yeah, when you're in the motion to accept the amended application,
Or the app.
or approving, when you're approving, absolutely. You're always gonna, and that's the other thing I forgot to mention is you guys know you have the ability to put conditions on any conditional use or variance application. You guys usually have staff here and you do a good job. Part of the problem is just be very clear on your conditions, and staff, if you have questions, please ask, because that becomes the zoning for the property. And the staff has to enforce that. So sometimes BZAs don't do a good job of articulating what those conditions are, and it leaves staff, it's subject to interpretation. So try to be as clear as you can.
Your recommendation is that if they were picking up on that and they wanted to amend that application on the spot, that we would make a motion to allow them to amend it, to accept the amendment,
Correct.
and then continue on with the approval based upon that amended application.
Correct. I think that's belt and suspenders approach.
Right. Yeah, no, agree.
I think you brought up a good point too, P. I think most folks that come in here in front of the board, zoning's kind of a foreign language to them sometimes, and you folks fortunately get to see almost cases every single month. So I think that's another important thing to keep in the back of your head, that a lot of times people may not understand the process, and so you might need some hand holding sometimes.
I think we do a good job of that.
Yeah, I would agree.
I think,
Everybody on the board does a really good job.
they're residents, you're residents, Yep.
Any question?
Also, hear a lot of comments.
Oh, yeah.
Yeah. My only complaint is there better not have been a buzzer beater while I've been standing up there.
Princeton did beat Arizona.
Yeah, I did.
Oh,
I'm not
Well,
even
Mr.
kidding.
Griggs, thank you
Yeah.
so much. It's definitely, it's always good information, and I know the folks who haven't been here as long. I appreciate that information. It's always great to get your perspective and refresher on it.
If you have any more questions, whatever, just get with Brett and he'll get a hold of me and I'll get you an answer.
Well, thank you very much.
Thank you so much. Thank you.
Uh-oh.
Concord.
Somebody crack it.
shattering important stuff.
Yeah.
I don't even have a
That's why I don't have a. Care less.
That's awesome.
Yeah, right, start it now.
That's the presentation you've heard.
Yeah, the new one. AC.
We still got this, so.
Is this affiliated with Carl Schneider?
Okay.
You know him, Carl?
Yeah, okay.
I know Continental.
Yes.
I think I've met Carl.
Okay, but this isn't
Here,
affiliated.
yeah.
Concord and Continental.
Are you ready to move on?
Quite a few.
Yep, yeah, we can cover some minute corrections
All right.
briefly, so the fun stuff.
So next on the agenda, we have the,
Yeah, for sure.
well, you can do it.
Thank you very much.
Okay, so let's start with the January 19th minutes. I appreciate some of you guys sending some corrections ahead of time. So for corrections for January, page 29, line 3, helps vent should be helps prevent. Page 30, line 19, continuous should be continuing. Page 39, line 3, paper cabinet should be paver patio. Page 48, line 21, this pole should be this pool. Page 2, line 23, the word is should be substituted with the word are. On page 10, line 23, remove the word we. Page 12, line 8, correct it to is this it, question mark. Page 16, line 9, regardless, should have a question mark behind it. Page 39, line 3, should be paver patio. Then page 43, line 19, used to picnic should be is depicted. So that's what staff received. I don't know if anybody else has any other corrections.
Anything else to add? All right, I'll make a motion to approve the minutes from January 19th, 2023, VA 2218 and VA 2219.
Second.
As amended. Thank you, Ed, correct.
All right, thank you. Those voting, Mr. Shipley,
Yes.
Mr. Trevs,
Yes.
Ms. Ross,
Yes.
Ms. Neff,
Yes.
and Ms. Sundar.
I think abstain.
Abstain. Okay. Motion carries. Okay, great. And then on to the February 16th minute corrections on page 13, line 3. Send a trap down should be send a trap gun. Page 8, line 12, will should be with. On page 17, line 11, should be so you have gone. Page 6, line 8, for should be FOR instead of FOUR. On page 37, line 4, after the word approve, should be inserted conditional use case CU-23-01, conditional upon. On page 38, line 21, there should be an added words at 14 feet 2 inches. That was continued to today. And then after the words 19th meeting. On page 13, line 11, 14.2 should be 14 feet 2 inches. On page 39, line 16, add they did have HOA approval. And then on page 48, line 16, benefit should be addendum.
Do we have anything else to add? All right, well, I'll make a motion to approve the minutes from February 16, 2023, CU 2301, VA 2218, and VA 2219 as corrected.
Second.
A motion by Mr. Shipley, seconded by Ms. Neff. Those voting, Mr. Shipley?
Yes.
Mr. Trevs?
Yes.
Ms. Ross?
Yes.
Ms. Neff?
Yes.
And Ms. Sundar.
Yes.
Motion carries. All right, I think that's all we have on the agenda for tonight. Thank you, folks, for all of you for coming out and attending. Pete and his team do a really great job. So hopefully you guys got a lot of good insight and carry that forward through the rest of the time.
Thank you for setting that up. It's important, and it was a good use of this time this evening.
Yeah, it's pretty rare. We kind of get a break in the cases, so figured we'd take advantage. Next month we do have 6 cases, so I guess it comes in waves where there's nothing and then quite a few. So
Feast and famine.
Thank you for being here.
yeah,
Yes.
So,
thank
yeah.
both of you.
I can't make it. So
yeah,
6
correct.
cases.
Yeah, yeah. You lucked out. So.
Anything else to add, anybody? All right, meeting